Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be talking about the case of ERLICH versus LEIFER and how it affects the liability of companies. Now to the fact of the case. This concerned the liability of a school for sexual abuse by its principal. The plaintiffs claim to have been abused by the principal between 2003 and 2006. The school was held to be primarily or directly and secondarily or vicariously liable for the act of the principal. The issue was whether LEIFER, the principal in this case, was the mind and will of the company. Now we have two things. We have direct liability and we have vicarious liability. So I'll be speaking on direct liability because that is what we need to discuss about here. Vicarious liability is a tortious claim. Now, the court held that she was the mind and will, thus making the school directly liable. LEIFER's power, control and authority was such that it was unrestricted and unrestrained. This abuse of power was built on disposition of unrestrained, unrestricted power, control and authority. LEIFER was the embodiment of the school, and it wasn't a question whether she was working within a course of employment or anything. She was acting within her appropriate sphere, which was administering daily operations of the school. Her conduct was thus the conduct of the school. LEIFER operated in a capacity without meaningful oversight or governance. The board had no role in receiving reports or overseeing LEIFER's performance as headmistress. LEIFER could do as she pleases, take girls out of classes and even take them home without being questioned. Various circumstances created a situation of unrestrained, unrestricted power, control and authority of the principal. At this stage, I don't think I need to spell out what just happened again. Here we have a principal who sexually abused children, and then they wanted the company to be directly liable, the company there being the school. Then the question then became, can you say that LEIFER's conduct is the conduct of the school? Can you say it is the conduct of the company? So much so that when there is a liability, such liability can be attached to the school or the company. Do you understand? Now, the court had to look at, LEIFER. Was she under any supervision? And then the answer was no. The board of directors of the school did not necessarily have to receive reports from LEIFER. They gave LEIFER unrestrained power, unrestrained authority, so much so that she could do anything within her work power. Do you understand? And therefore, she was acting not for the school or for the company, but was acting as the school or as the company. Do you understand? Do note that while you are interpreting the rules of attribution as well from the primary and the general, and also the rebuttable presumption rule in Leonard's case, do not forget that in Leonard's case, the court held that where a person is brought to the court, there is a rebuttable presumption that the person is acting as the company. It is the duty is on that person saying that he was not acting as the company but for the company to show that, to rebut the presumption. So you have the rules of attribution rule, you have the rebuttable presumption rule, you have the unrestrained authority and power rule. Do you understand? Where you start from is the rebuttable presumption, then go to the primary rules of attribution, then go to the general rules of attribution, then go to the unrestrained authority. Once all these four things click, then that person can be said to have acted as the company and not for the company. Now we are going to a very interesting part, which is section 91 of the CAMA. I want to juxtapose it with section 89A and B. We will see the difference, and then we are going to interpret it using as well the case of Freeman and Lockyer versus Buckhurst Park Properties. See you in next class.